So with that being said, we will jump into the board member certification course. I have them labeled here. It's 57 slides. Flight time is approximately an hour and 15 minutes. You can certainly use the Q&A section of the Zoom call to put down any questions that you may have. I will stick around after the end of my presentation and go through those particular questions and answer them to the best of my ability. So if something comes up, you have a question as we go through the different topics, go ahead and put it there and we'll just go one by one and go ahead and get through those. So the first question is, why are you here? So 720-3033 subsection 1 requires newly elected directors to certify in writing within 90 days that they have read the association's governing documents and policies. They will work to uphold the documents and policies, and that they will faithfully discharge their fiduciary responsibility to the members. As a newly elected board member, you should always execute this self-certification form. It's something that can be found on the DBPR website. And it's something that your property management company should be able to provide you. The reason I recommend that you do the self-certification is because we do not want to miss that 90-day window. So at the board meeting the members meeting where the new directors are elected, that form should be handed out to you and you should sign it and you should give it back to your property manager and it should be put in the official records. That being said, it is important for members to remain up to date on the latest developments in the law and to be able to ask questions and answers in these board certification courses are that opportunity. I do recommend that board members, even if they've already secured a board certification, attend every year because there will always be new developments. If you can take an hour and a half out of your time to get some free legal advice, I certainly would go ahead and do so if I had the opportunity. So when we go through today's seminar, the things we will talk about are budgets. That is the money coming in and the money going out of the association. We will talk about the election of directors in that process. We will talk about official records. What are those and how do we avoid the pitfalls associated with that? And lastly and finally, we will talk about covenant enforcement or HOA dispute matters. Probably the area that I end up practicing the most in enforcing the covenants or dealing with people accusing the association of wrongdoing. How do we address those upfront in the best way possible to, again, to put out the fire, and if not, to address and have legal counsel go ahead and handle it. So with that being said, before we get into budgets, before we get into elections and that, let's talk generally about what is an HOA. An HOA is almost a mini form of governance for a particular community. You see that through your governing documents. You guys will have a declaration of covenants and restrictions. That is the Bible in the HOA world. It is the document that has the most superiority over any and all other documents. You will have bylaws of the association. Those are the day-to-day nuts and bolts. How do we conduct a meeting? How do we pass a budget? How do we elect directors? How do we have a membership meeting? That will contain that particular information. You'll have articles of incorporation. Your articles of incorporation will set up the corporate structure, which in an HOA should be a not-for-profit, Chapter 617 entity, to operate and fulfill the duties set forth in the bylaws and enforcement or oversight as to the declaration of covenants. And you may have other supplemental documents. Not every association does, but sometimes you'll have rules and regulations. Sometimes you'll have ARC or ARB restrictions. And there may be other certain documents that pertain to, for example, the pool, usage of the clubhouse, or items like that. But generally, when I refer throughout this presentation to the governing documents, that is what that is. And uniquely to HOAs, everybody's governing document sits on by itself. The HOA for a client in St. Lucie County may not match the HOA governing documents for a client in Brevard County, and so forth. So as a board member, your job is to review those governing documents. And to the extent you don't understand a particular topic, why is this in there? It is your job to reach out to your manager to to get an understanding as to why that particular provision is in there, or what does this mean in the bylaws. And if your manager is unable to provide you guidance on that because it involves a legal question, you can always reach out to your legal counsel. But it's important for you all to understand the framework in which your association operates. Those governing documents is what establishes that framework. Now, in addition to your governing documents, you're going to go ahead and have Chapter 724 to statutes. That is the HOA Act. It came into being in the early 2000s out of the preeminence of the 617 statute. The HOA statute, for the most part, a generality, is a gap-filling statute, meaning when I get a question from a client, the first thing I do is look to see if their governing documents address a particular issue. For example, the election of directors. What is the threshold to amend the governing documents? Items like that. If the governing documents do not answer that question, the HOA statute is generally there to fulfill that void. So for example, I had a client come the other day and say, John, how do we amend our declaration? Their particular declaration did not contain an amendment provision. Well, the statute is a gap filling in that scenario. And the statute says it's 2/3 of the total voting interest. So that's the type of scenario we look at. I do not expect you as new board members or even seasoned board members to know every nuance of the HOA statute and every nuance of your governing documents. But I do think that you're required under that self-certification form to have a familiarity with what they are and what they provide. If an issue arises, the first line of defense for an association in assessing risk and trying to resolve an issue is for the board members to look at the governing documents. And boy, is it helpful when you know where to look because you have at least reviewed them before. So with that being said, that is my soliloquy on the HOA infrastructure and blueprint of what we look at, what we rely on. This is exactly what managers look at. This is exactly what legal counsel looks at. It's a little bit of insight there. So let's dive into HOA budgets. So this is going to be under 720.303 subsection 6. And this pertains to how do we set up a budget to estimate income for the upcoming year and estimate expenses for the end of the year. Those two figures put together will allow us to determine what the assessments should be charged to our members. So the association shall prepare an annual budget that sets out the annual operating expenses. The budget must reflect the estimated revenues and expenses for that year and the estimated surplus or deficit from the end of the current year. So when we look at the budget, and we're coming into budget season in October, if you're on a January 1st to December 31st budgetary year, you should be able to have a relatively good idea of where you're going to end up in December and determine if you're going to have a surplus, a carryover, money left over from last year's budget, extra revenue, or you're going to be in a deficit. And one of the elements that you need to look at is not only the revenues and expenses for 2023, but if we will have any money or any deficit at the end of 2022. When you're preparing the budget, you need to set out separately all fees or charges paid for by the association for recreational amenities. If you go to your management company, they will provide you a template budget. If you do not have a management company, contact your legal counsel. They will generally have a template budget, which you can at least begin to work off of. If all else fails and you don't have legal counsel, you don't have a management company, if you search the terms DBPR budget, the first return on Google will be about an 80-page document that the Division of Professional Regulation has prepared for condominiums to develop their budget. Now, you are not a condominium, but it has templates in there in which you can look at and start to understand what does a budget look like. So that's a good insight. Again, that's for condominiums. So there are some nuances because it's different than an HOA, but it will give you a good foundation to look at. So let's talk about you develop your budget. You work with your manager, looking at last year's revenue expenses, the upcoming year when we talk about landscape, when we talk about bulk communication services, when we talk about legal budgets, when we talk about administrative, when we talk about other expenses of the association and then what revenues we need to go ahead and fund that, eventually that budget has to be adopted by the board of directors. And so the question becomes, how is that done? Well, that is done at your annual budget meeting. Notice of the board meeting at which the budget will be adopted must advise members that the assessment is being adopted, but neither the proposed or final budget need to actually be mailed to owners. Just notice that a copy is free and available upon request. So what this really means is the statute, again, is the floor. I'm going to talk about best practices. The statute requires you have to send notice to all your members 14 days in advance of the budget meeting, unless your governing documents require more, stating we're going to have a board meeting, we're going to consider a budget, and that budget is going to result in the levying of assessments for the upcoming year. That's all that's required by statute. You are not required to put a copy of the actual budget in that mailing or that electronic communication sent to your members. I am telling you, as your legal counsel, always put it in there. There is no reason that you should tell your members you're going to adopt a budget and not actually have the budget enclosed or at least available on a link where they can go ahead and view. The whole idea of the notice is to allow the members to review it, to come to the board meeting and be educated as to the budget. In a Q&A session will take place between the board, the management company, and the members so that everybody can understand why certain expenditures are on there, why items went up, why items went down, and ultimately what the assessment will be on a per unit basis. So that should be provided to the members. The question I always get every year is, John, we went ahead and sent out the notice. It included a copy of the proposed budget. We did some tweaking over the past 2 or 3 days. We believe that we're going to have to modify the proposed budget that was sent out to the members. Do we have to renotice the meeting? No, you do not. You do not. That proposed budget is your first draft or maybe your second draft. It can still be modified within that 14-day period. It can be modified the night of the meeting. It is a starting point so that members can become informed. So if you decide to tweak the budget at the meeting or in the few days before, it does not require a new notice. You can simply go ahead and proceed with the budget meeting and adopt the budget and determine the assessments for the upcoming year. So one component of your budget, you're going to have your operating expenses, which I talked about, your management fee, your legal fees, landscape, bulk communication, stuff like that. Another section of your budget, which may or may not be required by your governing documents, is going to be reserves. Reserves is, think of it, the rainy day fund, the money we are going to put away so that when a particular deferred maintenance item, think infrastructure of the community, comes due, we don't have to levy a special assessment of $5,000 per unit to go ahead and pay for it. The pool requires resurfacing. The roadways require resurfacing. We had a catastrophic event and there's a large insurance deductible, a hurricane deductible, items like that. If you have money put away, and we'll talk about the strategies associated with that, it gives the board, one, the flexibility to take care of the problem immediately. And number two, nobody is met with, oh, a special assessment has been levied. Here, get out your checkbook and write us another big check. I recommend to every client that within their budget, they have reserves. There's a lot of strategy that goes into how you calculate that reserves, whether they're mandatory, whether they're voluntary. We'll get into the details and strategies associated with that, but you should have reserves, because the worst call I get from a client is, John, we had an engineer come out. We have this huge issue. We have no money to go ahead and pay for it. What do we do? And it's a very bad situation because you can specially assess. You could go out and try to get a commercial loan, which these days the interest rates aren't great. Or we could not undertake any action to go ahead and take the repairs and let the infrastructure continually deteriorate. So always, always have reserves. The question becomes how much reserves and what type of reserves. So reserves, in addition to operating expenses, the budget may include reserve accounts for capital expenditures. So those will be improvements to the property and deferred maintenance. Capital expenditure, a good example, we have a lot of clients that pickleball apparently is a very big thing these days. My in-laws play it, they love it. I don't think I'm at the age yet where I'm old enough to get out there. I still play a little bit of tennis when I can, but at some point I can see that in my future. Well, a lot of clients are coming out and saying, hey, we want to install a new pickleball court. That would be a capital improvement, right? You're improving the common facilities of the association. Deferred maintenance would be the infrastructure that currently exists, the roadways, the clubhouse, the pool, items like that. So let's talk about the two different types of reserves. I'm first going to talk about mandatory reserves and what is that. And then the opposite of that is voluntary reserves. Mandatory reserves are reserves that are established by a vote of the membership or provided for in your governing documents. So the way I assess if a new client comes to me and says, John, do we have mandatory reserves, which have certain requirements for funding, or do we have voluntary reserves, which have more flexibility as far as funding and what categories there are? I always go ahead and look at their governing documents. Generally, it's in the declaration or the bylaws, but it will talk about reserves and not the board may reserve, the board shall reserve. And if there's that will, shall language, you have mandatory reserves. And then it becomes a question of, well, what categorization? Do we have straight line? Do we have pooled? Again, we'll talk about that, but you have mandatory reserves. The other way you can get mandatory reserves is we have meeting minutes. We have a membership meeting where the members voted to require reserves. Those are the two ways that you have mandatory reserves. There was formerly a third way where the developer initially established reserves. As of, I can't remember if it was last year or the year before, that was written out of the statute. So now we're just down to there should be meeting minutes or it's in my governing documents. And if it's not, we're going to presume those are voluntary reserves. And again, I'll explain what those are at a later point. Mandatory reserves are the amount reserved in a mandatory reserve account computed by means of a formula based upon an estimated remaining useful life. How much longer do we have on our roadways? And the estimated replacement cost. What's the cost to replace our roadways for each particular item, and it's adjusted annually. There'll be a chart coming up in a few slides that addresses and we'll go through what a reserve schedule looks like. That'll kind of put meat on the bones here as we talk about what the statutory definitions are. So there are two types of mandatory reserves. There's straight line funding and there's pooled reserves. Think of straight line funding as different buckets that you have to put money into every single year. So I'll have a bucket for the roadway. I'll have a bucket for the clubhouse. I'll have a bucket for the playground. I'll have a bucket for the pool. I'll have a bucket for the lake banks or irrigation pumps. Those different buckets. And every year when I set up my reserve schedule, I say, this is how much I need to fund this year. And I put that money in that bucket. And that money has to stay in that bucket unless the membership allows me to move it to another bucket or to not fund that particular bucket. But it is walled off and separate and apart. So hurricane comes through. Giant hurricane deductible has to be paid. John, we don't have a reserve account for that. And we don't have the operating to fund all of it. But we do have money in a roadway reserve, in a clubhouse re-roofing reserve, in a pool resurfacing reserve. Can we use that money to pay for the hurricane deductible and then reimburse it? Not without the membership vote. Any movement from in a straight line methodology from bucket to bucket to bucket requires the membership to have say in that. And we'll talk about what the requirement is in the membership vote. But as you can imagine, when you have a peril, a hurricane deductible, it has to be paid. There's not a whole lot of time. It's not that easy to go out to your members and say, hey, in 14 days, we're going to have a meeting. Can you mail back in your proxy? It's just not easy. So straight line reserves have their purpose. They're the original type of reserve account in the HOA world, but they are not what I recommend to clients. What I recommend is either voluntary reserves or the best type of reserves is mandatory pooled reserves, and we'll get into what that is. So when you talk about straight line reserves, the total amount necessary to bring any negative component balance back to zero, and then you talk about the total estimated deferred maintenance expense or estimated replacement cost of the reserve component less the estimated balance of the reserve component at the beginning of the period of the budget will be in effect. The remainder, if greater than zero, shall be divided by the estimated remaining useful life of the component. Now, if you can imagine, when I'm studying for the bar exam or my board certification, I look at that and I go, what does that mean? Right? And I've been practicing this area for almost 13 years, actually over 13 years now. That's okay. You as a board member should sit there and go, what does that mean? But again, we'll go ahead and go through what that means. So this is a sample straight line mandatory reserve schedule. This is what your management company should be able to go ahead and provide to you, or if you don't have one, your legal counsel. But this is the type of document you use to determine how much money do I need to put away for each bucket. So I don't know if you can see my cursor here, but it talks about in this particular column, the reserve item. So the question I always get from clients is, well, what do we reserve for? We know we should have them. What do we reserve for? Well, it should be any deferred maintenance item which requires replacement and its useful life is beyond 1 to 3 years, right? So roofs on the clubhouse in an HOA, pavement resurfacing, painting of the building. I have some multifamily HOA clients where the association is responsible to paint the exterior of the buildings. Elevators, if you have an HOA that would have elevators, clubhouse roof replacement, walkways improvements. We also see lake banks, tennis courts, pickleball courts, basketball courts, any infrastructure that would have a lifespan in excess of 3 years that will have a significant price tag that cannot be absorbed into the annual operating budget is realistically should be on this. One recommendation that I give many clients is instead of you identifying what the categories should be in the estimated useful life, remaining useful life, replacement cost, you can hire a reserve analysis company to come out. They typically, depending on the size of the association, $2,500 to $5,000. You do it every few years. They will come out and identify the deferred maintenance items, and they will give you the useful life, the estimated remaining useful life, the replacement cost. They will set this up for you. Some clients don't want to spend the money. I can certainly understand it. Depends on the type of your community. The 1,000-unit HOA, it's a no-brainer. Of course, you do that. The smaller 20-lot HOA that really doesn't do a whole lot, that's a big expenditure, $2,500 to go ahead and do that. So it depends on the client. But remember, you have a fiduciary obligation to your members. One of the best ways to ensure you've exercised properly that fiduciary obligation is to rely on the professional advice of your management company, of your reserve study company, and of your legal counsel. And if you do that, it's very hard for the members to complain that you're ignoring your obligations. So it's something that I do believe that most clients should consider. Again, I'm sure that Vesta could recommend a multitude of vendors that could provide those services to their HOA clients. So let's talk about, you have the reserve items. The estimated total useful life. That is how long is this particular component scheduled to last. So let's just talk about roof replacement. The roof in this scenario, the professional opined, will last 12 years from the date it's first installed. Estimated remaining useful life is how many years it has left. So under this scenario, the professional says it's a 12-year roof. We're on year 11, meaning there's 1 year left to go ahead and do it. And here's the estimated cost for deferred maintenance capital expenditure, right? So that's how much the roof is going to cost. And this is how much we have on hand, right? So we know it's going to come due next year. We know we have $87,000 on hand, John. How do we go ahead and get to the 95, which is the replacement cost? Oh, we put $8,000 in this year. 8,000 divided by the number of units, and it becomes very easy to figure out how much we're going to put in the roof replacement and how much each owner is putting into that by virtue of their assessment. So this is the type of chart that you put together. At the very bottom here, you're going to have your totals, right? So this is the total amount of money you would need to replace all of the infrastructure deferred maintenance items in your community. This is how much you have on hand. Rarely will these two match because you have remaining useful life as to some items. Let me see if I can go back here a second. And so you see you have 9 years left on this one, 14 left on this one. So of course, the balance you have on hand is not going to match the amount you need to have when everything comes due. And then this last column here, that's the most important piece of information in preparing your reserve schedule for your budget. That is, how much do we have to put in this year, right? So we know it's $8,000 for the roof. We know resurfacing for the pavement is that, building painting and so forth. $36,312. That's how much money we're putting in our rainy day fund this year, John. Great. We divide that by the number of units, and that is how you go ahead and come up with your reserve schedule. So I talked about earlier mandatory straight line reserves, the buckets, right? The better option, it's a little more expensive because it typically requires a CPA to balance, is a pooled reserve. A pooled reserve is where instead of individual buckets for pavement, painting, roof, and so forth, we have one giant pool that all the money pours into. And if any particular deferred maintenance item comes due, we can pull the money out of all of it and pay for that. And then at the end of the year, we have to rebalance based on the new useful life of that component. So this becomes very, very essential when you have a large project that comes due early. So if you have a roof that begins to leak, your estimated useful life stood at 5 years left, but the professional is opining it's got to be replaced this year. Well, we don't have enough money this year. What do we do? In a straight line funding situation for reserves, you would have to go borrow the money or levy a special assessment or get a membership vote to go ahead and move that money from another reserve account into the roof to go ahead and undertake that work for this year. In a pooled, the board can go ahead and just reach into the giant pool and pull the money out necessary to replace the roof and then recalibrate at the end of the year when preparing the next year's budget. And so this is the statutory definition when you talk about pooled reserves. You can read it. It's on there at the end of the presentation. If you want a copy of this presentation, email Brenda and her team. They will go ahead and get you a copy of it. But it is a better methodology. The reason it requires a CPA to calculate is because of that rebalancing requirement at the end of every year. If we pull out early, that throws all of our formulas off, right? Because we pulled out early and that roof wasn't fully funded, but that's okay. We got the problem solved. It's a funding issue, right? But we fixed the problem. The roof no longer leaks. So there's a new useful life. So we have to recalibrate. If you have a CPA on the board, they could probably do it. I certainly, as your attorney, being not the best at math, I will defer to your CPA and go ahead and prepare that. So let's talk about mandatory reserves versus voluntary reserves. So a mandatory reserve, whether you're the straight line methodology or you're the pooled methodology, the board has to fully fund it. Meaning that if we go back a couple slides, that $36,000, the board doesn't have discretion to say, well, the economy's been hard this year. We're not going to put all that money in, right? And we're not going to assess all the owners for the full $36,000. You do not have that option in a mandatory reserve situation. When the board sends out the budget and attends the budget meeting, they must propose a budget that fully funds reserves, whether it's a pool or a straight line. However, the membership can authorize the board to partially fund or not fund at all the reserve account for that particular year. So the strategy that I typically see for boards is we are going to propose a fully funded reserve account as required by statute. But when we send out the notice of the budget meeting, we are going to simultaneously conduct a membership meeting at which we're going to give the members the opportunity to allow us as a board to adopt a partially funded reserve account. It's not a strategy that I recommend be used because I think you need to fund that fully fund that rainy day account, those reserve accounts. But it is a strategy that I have had clients implement, especially in the times of COVID, where people were very scared about what's going to happen. Boards wanted the opportunity to give their membership some flexibility. All the other operating budget went up, and they said, well, if there's a way that we can go ahead and keep assessments level, it's to partially fund reserves instead of fully funding reserves this year, and they implemented that methodology. Again, not something I recommend, but there is a methodology to go ahead and do it. So what does it require to partially fund or waive reserves for a particular year? It requires a majority vote at a membership meeting in which a quorum is established. So that does not mean a majority of your members. That means that you have to have a meeting. You have to establish a quorum, which pursuant to statute is at least 30% of your membership. And a majority of those in attendance have to permit the partial funding or waiver of reserves. It is only applicable to the year. So let me walk you through a hypothetical. For the 2023 year, we send out our budget. We want to partially fund reserves. Instead of putting away $36,000, we want to put out $18,000. We send out notice of our budget meeting. We propose a fully funded budget, but include in there an alternative budget, which only funds reserves at $18,000, and request the membership vote on whether they want the fully funded budget, meaning they disagree and will not agree to waive reserves or partially fund reserves, or they will agree to the alternative budget and agree to partially or authorize the board to partially fund reserves for that upcoming year. We show up at the budget meeting. The first thing we do is we go ahead and have the membership vote. We ensure we establish a quorum through limited proxies or people in person that are attending. Once we've established a quorum, we determine, did a majority of those present vote to partially fund reserve? That they selected the alternative budget of $18,000 instead of the full $36,000. If they did, the board now has the permission of the membership to adopt the alternative budget, which would be the $18,000 instead of the fully funded reserve. So I went kind of quick over that, but that's the scenario that we typically go ahead and see. What happens if you have mandatory reserves and you want to get rid of them? So you just want to have voluntary reserves. Well, mandatory reserves may be terminated by the approval of a majority of the total voting interest. So again, to waive or partially fund reserves for 2023, majority of those present at a membership meeting in which a quorum is established. If you want to get rid of the mandatory reserves altogether, right, so the board does not have to adopt budgets that fully fund reserves. It's a majority of the total voting interest. So we talked about mandatory reserves and the subsets of mandatory reserves. Let's talk about voluntary reserves. Voluntary reserves are reserves, or they're what's left over, right? So I'm your new legal counsel. I look at your governing documents. It contemplates that the board can have reserve accounts, but it's not mandatory. It doesn't say shall, it doesn't say will. It says the board may have reserves with the budget. And then I take a look at your annual meeting minutes and other membership meeting minutes. The members have never implemented or required the board to implement mandatory reserves. By default, you have voluntary reserves. That's what's left over. The advantages of voluntary reserves is they are, one, the amount, the categories, and everything else are completely controlled by the board of directors. No membership input is required in establishing reserves. And the board can go ahead and fund as much or as little of the reserves as it wants to. So if you have a good board that is judiciously exercising its fiduciary obligations, they will, under most circumstances, end up at or near where a mandatory reserve would be, because they should be putting that money away. They should be hedging against future deferred maintenance expenses. So the voluntary and the mandatory typically and practically should end up at about the same place. But the difference is, with a voluntary reserve, the board could decide that we don't want to fund $36,000 this year. We just want to fund 20, right? And there may be a myriad of justifications for why they want to do it. But the point being is they don't want to impose upon the members an increase in assessments. And so they're only going to partially fund. The example I gave previously about mandatory, membership input, membership vote, alternative budgets, and so forth. In a voluntary, the board just sends out the budget, what they think is right and what is wrong, right? They just send out the budget and the notice of the meeting with the $20,000. That's what we're going to adopt. If you want to show up and argue that we should increase assessments more and reserve more, please do so. But at the end of the day, the board has full discretion here and does not require membership input. The board can identify a different formula for calculating reserves than what is required by statute with that chart I showed you. The only downside to this is twofold. One is there's certain disclaimers that have to appear on the budget and could create issues with people securing financing in your community from lenders. And number two, sometimes you'll get a board in there that their only goal is to not raise assessments. And so they will end up, because your contracts for cable, for landscaping, for management have escalator clauses, and those go up typically every year. They will partially fund or not collect reserves to maintain that flat level of assessments. I can make arguments for and against, but it could result in a regime of a particular board deciding we're not going to put away money. What does that result in? That results in, if a particular deferred maintenance item comes due, they have to go ahead and specially assess or go ahead and get a commercial loan to go ahead and pay for that. So it allows the board to be a little short-sighted. There's advantages and there's disadvantages to that, but this is certainly the maximum flexibility that exists. I have a lot of memberships that require mandatory pooled because they want to force the board to fully fund. They would rather plan for the future and know that they will not receive a special assessment notice and pay a little bit more over time in increased assessments than to run the risk of a partial funding or no funding in a voluntary reserve situation, and as a result, end up having to face a risk of a special assessment. So I talked about when you have voluntary reserves, you have to have this disclaimer on the budget that's mailed out to the members. And this is statutorily required. It's a copy and paste job from the statute. Your management company should be able to walk you through how that's done. But essentially, this is a warning to all members who receive the budget and lenders who will want to look at the financials before loaning in the community for the purchase of homes, that you guys do not have mandatory reserves. It may dissuade a purchaser in the community. It may dissuade a lender from lending in the community. So it is the scarlet letter of the HOA finance world. In a budget that has only voluntary reserves, although not as extreme, there is a disclaimer that's required in there that says, yes, we do have reserves, but at the end of the day, we're not required to have them. And so again, this would appear on your, not only your financial statements, but also on your budgets. The reason that it used to not be a big deal before the 2008, 2009 crash. Lenders very rarely went ahead and looked at association finances to determine the stable or stability of the HOA. But it's certainly in the condo world, they are now requiring this with the Surfside legislation. In the HOA world, we are seeing it become more and more something that lenders want to go ahead and look at. If you have mandatory reserves, it becomes a very easy decision for that lender, assuming that the buyer qualifies otherwise. If you do not have mandatory reserves, or you don't have reserves at all, I have seen some Fannie Mae lenders clutch at that and either not underwrite or create some other hurdles that have to be overcome as part of the underwriting process. Again, the goal here of an HOA is to make sure your property is as marketable as possible to keep the property values up. Hence another reason, or in the column of mandatory reserves, are something that every association should consider, weigh the risks and benefits as I've outlined in the presentation. Alternative use of HOA mandatory reserves. So reserve funds and any interest accruing thereon must be used only for the authorized reserve expenditures unless their uses for another purpose is approved in advance by a majority vote of the members at a meeting in which a quorum is present. So I went in and spoke about this, but this is if you are in a straight line mandatory reserve situation and you want to go ahead and use money from the roof reserve to pay for pavement resurfacing because that came due early, you have to go to the members to get a vote. In a pool reserve scenario, the only time this would apply is if we outlined our reserve categories and we missed one, and if the category is not within our pool, but it comes due, we would have to go to the members to use money outside of the designated pool on that particular deferred maintenance item. If you use a professional reserve study company, that should never happen. So it wouldn't be a worry. All right, that is it on budgets. So now we'll jump into something a little more exciting, HOA elections. So if you have not had your HOA election yet, certainly you're going to be going into that season. I typically see my clients starting in November or December, and all the way through April, the new board of directors is elected. In the HOA world, this is document driven, governing document driven. It is not statutory driven like in the condo world. The Florida legislature made the condo world said, we don't care what your governing documents say. It is this methodology to elect your directors. In the HOA world, it's very, very document driven. So take a look at your bylaws, take a look at your articles of incorporation. Those are generally where it talks about how are directors elected, how are they nominated, how are they elected, and that will be controlling. If there is any ambiguity or any question, I cannot tell you how much I encourage you to talk to your management company and talk to legal counsel. I can go ahead and generally review a client's documents, prepare the limited proxies in an outline of the notices and when those have to be sent out within an hour to an hour and a half time, right? If you foobar an election and you don't allow nominations from the floor when you were required to, or you didn't have a nominating committee when you were required to by your governing documents, and someone challenges that, one, you're going to have to redo your election anyways. And two, you may end up in DBPR arbitration, which means legal fees, right? That will well exceed the hour to hour and a half time of legal fees. And recall that unless you do an amendment to your bylaws or articles, you only have to pay for the legal fees once, because every year it's going to be the same methodology unless they change the statute. So it is worth your time to have legal counsel review and sign off on what the management company is sending out to the members for that one-time consultation, and know that you are on solid ground. So long as you follow the procedure outline, we know we're going to have a valid election and we won't run the risk of a challenge. So anything to do with HOA elections, and again, this is the gap filling element of the statute, is going to be under 720.306 subsections 8 and subsections 9. Most importantly, take a look at that first bullet point. Elections must be held and conducted in accordance with the governing documents, right? So the statute says, we don't really tell you what to do, look to your governing documents. And except as provided by statute, all members of the association are eligible to serve, and any members may nominate themselves from the floor. Notice that I emphasize the word members. I always get a question, it comes up 3 or 4 times every year. What is a member, John? Well, a member is defined by your governing documents. So I have some governing documents that say you have to be the record title owner, meaning if your name is on the deed, you're a member, you can run for the board of directors. But if my wife is not on the deed, she is not eligible. That's one instance I've run into. I've run into other instances where it says a member is defined as the record title owner and their spouse. So even if my wife is not on the deed, she is deemed a member by virtue of that definition, and she is eligible to be a candidate and run for the board of directors. The issue always becomes that we set up this election process, we're headed into election night, and somebody comes to the manager and says, I don't think this person's eligible for some reason, right? They're not on the deed and we require you to be on the deed pursuant to the definition of a member in the bylaws. And then I get the call and I have to tell them they have to call off the election and we have to reschedule it because we missed that when we were determining who is eligible to appear on the ballot or the limited proxy sent out to the membership. So very important that you define who is a member and have an understanding of what that is. When people put their name in the hat, that we verify that they're a member, and that you'll see on the next slide, they meet the additional qualifications. But understand that we start with, so long as they are a member as defined by your governing documents, they are permitted to run for the board of directors. Now, when is a member not eligible to run? So if they are delinquent in the payment of any monetary sums owed to the association on the last day that he or she could be eligible, I'll talk about that in a second. And if I've been convicted of a felony where my rights have not been restored for at least 5 years. I do not recommend that we run background checks on everybody that wants to be a director. I don't think that's necessary. But if there is some substantive allegations that a member who is trying to run for the board has a felony conviction, pick up the phone and talk to legal counsel, and they will walk you through how to analyze that. Maybe it's a Google search, maybe it's sitting them down and having a discussion, right? But we want to make sure that they are eligible. Let's talk about the delinquent issue of this. So I went ahead and I recently at my community lost my pool tag, right? The fob to go get in the pool area. $25 replacement, right? So I go to the office, I get my key fob replacement, it's 25 bucks. I say, can you just put it on my account, right? And I'll pay it when I pay my next assessment. And I forget to pay it with my next assessment. I pay my assessment, but I forget the 25 bucks. I have a monetary obligation owed to the association. If I wanted to run for the board of directors in my community on that scenario, I would be ineligible. Now, I did pay my $25, just so everyone knows, but I would be ineligible. It can be as simple as that. It could be a fine that remains unpaid. It could be unpaid assessments. But if money is owed to the association and I get to the nomination deadline and I have not brought that current, I am ineligible to run for the board of directors. So if you are putting your name in the hat, it's very important you have a conversation with the management company, right? Or with the bookkeeper to say, am I current? I just want to make sure I'm not missing anything. There's not some interest charge that I didn't pay 2 years ago that's just sitting on my account. Am I current? And when the management company gets to the nomination deadline, it's important for them to have an AR sheet showing everybody who's delinquent to the association and make sure that every nominee who is running for the board of directors is not on that AR report. So HOA elections part 2, if the governing documents of the association permit candidates to be nominated in advance of the meeting, then the association is not required to permit nominations from the floor. I want you to think about this, the opposite of what that says. Assume for your association that you have to allow nominations to become a candidate for the board of directors up to the night of the annual meeting, meaning we're going to show up at the annual meeting, and one of the things we're going to do is ask, are there any nominations from the floor? Is there anybody else that would like to be a candidate and have people, or I'm sorry, be eligible for people to have cast a vote for them to be on the board of directors? The only exception to that is if your governing documents provide for an advance nomination provision. Specifically, it will say you got to put your name in the hat by 40 days before the election, 30 days before the election. It will set forth a procedure by which there is an advance nomination cutoff, meaning that after that date, we know how many people are going to be on the ballot. We know that every person that's on that ballot is defined as a member of our association. We know that they're current, and we know that they do not have a felony conviction. But that has to be in your governing documents. If it's not, you are required to have a nominations from the floor. If there is an ambiguity in your governing documents, meaning that it says the association may require advance nominations or something like that, talk to your legal counsel. That's one of those things that when I'm looking for a new client and saying, how do we do an election? We just want to make sure we're doing it right. That's one of the items in my legal opinion is you have advance nominations, so this is the cutoff date, or you do not. And as a result, you can establish a date that you want people to put their name in the hat by, but at the meeting, you still have to allow nominations from the floor. So understand that process. Look at your governing documents. If you don't know, if it's not abundantly clear, talk to legal counsel. So HOA elections part 3, unless otherwise prohibited by the governing documents, members may vote in elections in person or by proxy. So what this means is if I show up on the night of the meeting, I am handed a ballot when I check in with the manager. They check my name off the list. John Carrogan's here. They hand me a ballot. I fill out my ballot and I go put it in the ballot box, right? That's easy. That's what everyone thinks of when they think of elections. Think of a limited proxy almost like an absentee ballot. Distinguishable, right? Because it's not defined as an absentee ballot. That's a different thing, but it's equivalent to. It's a piece of paper that's mailed to you with the second notice of annual meeting or the notice of the annual membership meeting and election that has the candidates that have put their name in the hat. I check who it is, right? I sign it, and I mail it back to the association. And if the proxy holder is left blank, the secretary of the association by default will cast a ballot as you've instructed on that proxy. So if I vote for my 3 candidates, I sign the limited proxy, I mail it back to the association, the secretary will cast a ballot on my behalf for those people that I've chosen. They're required to by law. I can still go to the annual meeting, right? I just don't have to also then do a ballot because it's being done on my behalf. I've already cast my votes. And the governing documents may also permit members to vote in elections by secret or absentee ballot. That'll be on the next slide. I'll walk you through that process. Jumping back to the first bullet point there, understand that if you cast a limited proxy, that is not secret, right? There is no secrecy with that. That's an election document. Your name will appear on the document because you have to sign off on it, right? And it will tell everyone who you voted for. So some clients say, we want to have secrecy of the ballot. That's important to us. And so there's a way you can amend your governing documents to have what's presented as an absentee ballot. Again, I'll go over that in the next slide. But essentially, it allows you to go ahead and maintain the secrecy of the ballot while achieving the same results as a limited proxy, meaning people don't have to be there in person to vote. So absentee ballots, if any of you ever lived in a condominium in Florida, this is the system that the statute requires for condos. It's a double envelope system. The outer envelope allows the association to ensure that you cast the ballot because it has your lot number in an HOA or your address and has your signature on it. And then the inner envelope has the ballot. And so what happens is that the inner envelope has no identifying markings. You essentially get your package, right? I have a ballot. I fill out the ballot with who I want to vote for. I don't sign it. I don't do anything. I just fill out who I want to vote for. I fold it up. I put it in my inner envelope. Lick it, seal it. There's that. I then take my outer envelope, right, which is equivalent to my proxy. I put my inner envelope in the outer envelope, lick it, seal it. On the front, I put my address, lot number, and sign it. When the association gets that back, they can then confirm that John Carrogan went ahead and turned in his absentee ballot, right? Because they can see my name, they can see my lot number. They'll mark it on the list that they've received it, so I can't double vote. And then they will remove the inner envelope and place it in a bin at the election night. That inner envelope is then mixed in with all the other inner envelopes, right? But it's separated from my outer envelope. So now nobody can tell who I voted for. So it is a way to maintain the secrecy of the ballot, but still understand who was casting the vote. I'm sorry, casting a vote, not who you voted for. Let's talk about HOA board vacancies. So unless the governing documents provide otherwise, the vacancy is filled by the remaining directors at the board's discretion. So what that means is we elect a new board. Everybody's getting along. We have a particular board member who has a health scare and they decide that there are things more important to them, being with family and friends, than running the HOA. Believe it or not, that happens fairly occasionally when we live in Florida. There's now a vacancy on the board. The board can, pursuant to statute, check your governing documents because this is a gap filler provision. But generally, most associations provide that the remainder of the board can fill that vacancy, option A, or conduct a special election, option B. I always recommend that you just fill the vacancy, especially if it is a annual election, meaning everybody's elected or reelected every year. Conducting a special election has costs to it that you probably didn't budget for. And as a result, it can result in additional operating costs that aren't necessary because the board could just fill the position for the remainder of that director's term. And unless provided otherwise by the bylaws, the appointment is for the remainder of the term. So what that means is if we're reelected every year and we have a director resign in September and the election's in November, the replacement, if that position is filled, is only till the upcoming election. If you're staggered terms, meaning you're elected for 2-year terms, and I resign during my first year, the person who fills my seat would serve the remainder of my term, meaning they would go past the November election and all the way around to the following year's annual election. One thing that we are seeing more and more clients go to is electronic voting. All of the election items I've identified under the statute presume that everything is snail mailed to you, right? So you go ahead and we want to do an election. The notice of the meeting is mailed out. The limited proxy is mailed out. The absentee double envelope absentee ballot is mailed out. People get it in the mail, they turn around, do it very quickly and mail it back in. That's great. That has worked for many, many years. I have no problem with it. But we're in a world where now electronic voting has been somewhat widely adopted. And so the statute was amended in 2016, 17, 18 to contemplate the process by which the association, through a board resolution, can implement a procedure for people to opt in to allow them to electronically vote. The vendors out there that I have worked with have been very good at what they do. And certainly I'm sure Vesta could recommend some vendors, or Vesta may have an in-house program that provides this capability. But it is a methodology that exists. Many, many clients in the past 2-3 years have implemented this as an option. Note I keep using the word option. You can't force members to electronically vote. You can only give members the opportunity to opt in to electronically vote, which you get an email, you put in your password, it opens up into a ballot on a website, you fill out your ballot, you electronically sign it, you hit submit, and then it goes back into the World Wide Web. And then on the election night, we can show up and see who people vote or who's voted, one. And if it's a limited proxy situation, we'll know who people voted for. If it's an absentee ballot situation, we'll know that somebody voted, and then there'll be a secrecy at the ballot. But that's practically how these things apply. The reason is it's optional is it's an opt-in process, meaning you can only tell members, hey, we have this new way you can vote. If you want to opt in, please fill out this form. And members that opt in will then get an email in lieu of physical mail. But you can't force members. So no matter what you do, every client I have ends up in a hybrid situation where we have hopefully a vast majority of the members that use electronic voting because it's easier, it saves money than having to mail everything out at the night of the election. We already have the totals for people who have electronically voted. But there will always be those holdouts, people that still like the stuff in the mail for whatever reason, and you have to allow them to continue to vote by mail. So it is a hybrid process at best. So the board of directors, in order to do this, must adopt a resolution authorizing online voting. That meeting and where it's done, it requires 14 days notice to the membership that they're going to consider this resolution. The online voting procedures have to be consistent with your bylaws, and you have to hire a third-party vendor, and you're going to have to pay them a fee to handle this process. I am not aware of what those fees are. It's typically on a per lot basis, but you got to compare that to your savings on mailing costs and so forth. Understand that if you're going to do this, our firm certainly has an electronic voting package with the resolution that we tweak to every individual client based on what their bylaws say. But it's something that your legal counsel can go ahead and provide to you if you decide to proceed down this route. Members must opt in writing, which is kind of ironic. If I want to opt into electronic notice, I got to turn in a form. But certainly if the board adopts the resolution, in our package we give to clients, there's the opt-in form, right? So you just mail that out to members and have them sign it and send it back. Any member voting electronically by way of an electronic voting system shall be counted in attendance. So much like when you turn in your limited proxy because you can't be at the meeting, if you turn in your electronic ballot, you're counted as being at the meeting. And a member's consent is valid until they opt out. So once I have the opt-in, I don't every election year have to go get a new consent. They're in until they opt out. All right, so that brings us to the end of HOA elections. The biggest thing is consult with legal counsel for that one-time consultation. If you want to do electronic voting, again, consult with legal counsel. Other than that, I can tell you that I have had many clients that use Vesta to run their elections. Please, please, please have your management company run it. They are so experienced and know how to address issues, and people that show up that are confused or may have sent something in but didn't do it the right way, they can fix those problems during the check-in process. So rely on your management company to professionally execute your election and get that new board into place. All right, we have 2 topics left. We're at 29, but the next ones go fast. So let's talk about HOA official records. So these are records of the association that are subject to inspection by members. I hear many clients when they're first on the board of directors refer to the sunshine laws, the HOA sunshine laws. Well, sunshine law in Florida really applies to governmental entities and agencies. It does not apply to HOAs and condominiums, but we have a very similar provision, meaning that if you want to conduct association business and a quorum of the board is present, you got to do it in the open, right? That's much like how you have to have county commission meetings in the open, city commission meetings in the open. You can't do it behind closed doors. Also, much like in city government, records of the association, we'll go over what those are subject to inspection by members. So if members want to see the financial statements, if members want to see copies of violation letters, if members want to see the account receivable report or ledger as it pertains to a particular property, if they're a member, they're entitled to make the request and they're entitled to view the records. The best way to think about HOA official records is realistically presume that everything is an official record unless, and I'll go through the exceptions, it's an exception to the rule. So official records of the association have to be kept within 45 miles of the HOA. They have to be maintained within the state. They have to be produced for inspection within 45 miles. Many clients nowadays opt, instead of having the file cabinet at the association office, to store everything in the cloud. Frankly, I think that makes it a lot easier because you can just send your members links if they want to look at a particular document, or you can have them printed out or ability to view it on a computer within that 45 mile. But that is a requirement to be made available within 45 miles. So if your management company has their nearest office is 55 miles away, you're making those records available within 45 miles. There's no exception to that. The story why that is a requirement is there was a legislator in Tallahassee whose grandmother was quite adamant of doing every month. I wanted to see all these financial records of the association. She was down in Miami. The association got cute and decided that they would make the records available for inspection, but only up in the panhandle of Florida at the management company's alternative office. The legislator whose grandmother was making those requests found out about that, and the next version of the HOA statute that came forward in 15, 16, or 17 included this provision. So not something any of my clients would certainly do. We're going to be professional. We're going to make records accessible, but you can do it up to 45 miles away. And the association records must be kept at least 7 years. That's a pretty big timeline. It must be made available within 10 days of the receipt. So there are certain items that I recommend an association keep beyond the 7 years. Those would be insurance documents, because you never know when you have to make an insurance claim, warranties, plats, site plans, contracts for work on deferred maintenance items or capital improvements, stuff like that. But items that don't have to be kept 7 years, account balance ledgers, not necessarily something you want to do. So what I recommend is implement a policy that talks about what kind of records we're going to maintain forever and what kind of records, once we get past 7 years, that we're going to once a year do our spring cleaning and make some more room in a file cabinet. So what is an HOA official record? Again, I recommend you, because there's going to be a catch-all here, treat everything as unless it's accepted, but we'll go through them. Copies of permits and warranties related to construction of the community. Copy of the governing documents, pretty obvious, you should always have those. Copies of the articles, copies of the declaration, again, those governing documents. Copies of the rules, meeting minutes of all board of directors, meetings, and members. So this would be not only your board meeting minutes, but your membership meeting minutes. I recommend those be kept perpetually. They should never be thrown away, because you don't know how many times I've been involved in litigation where the association is being sued because something came to light and the decision that resulted in the dispute was made 14 years ago. for some reason. A fence was installed in some location and the new homeowner is upset and has sued the association. If I have board meeting minutes that reflect why it was done and it's helpful to my case, boy, is that great to go ahead and have. So always go ahead and keep your minutes, especially because they can now be put in the cloud. Current roster of all members, their mailing addresses, right, and their parcel identification. The association's email addresses that are part of the opt-in form, right? So we talked about that electronic consent form for electronic voting, electronic notices. Those would be what's included in there. And all insurance policies of the association. Copy of all contracts, management agreements, attorney retainer fees, and so forth. Landscape contracts, bulk cable contracts, those types of things. The financial accounting records of the association, according to GAAP principles, good accounting practices. The financial and accounting records must include anything that results in the financial accounting of the association. So that could be anything from the actual bank statements, copies of checks, monthly financial reports, cash flow statements, audits, and so forth. Current account of periodic statement of accounts for each member. So that would be your assessment ledger for the members, tax returns, financial statements, anything that has to do with finances should be kept for those 7 years. A copy of the disclosure summary, which essentially is something that's supposed to be provided when a new owner purchases in your community that, hey, there is an HOA here and there's governing documents. Here's the catch-all. All other written records of the association not specifically included in the foregoing, which are related to the operation of the association. And so that would be anything and everything, unless it's accepted. So importantly for this, there's not a slide on it, but I do want to point out board member emails between board members are not official records of the association. They are subject to subpoena if there's litigation, so then they may still see the day of light, but they are not official records of the association. Now, you copy the manager on those emails, and they are official records of the association. So we always want to keep our managers informed, but sometimes if the board is communicating to build a consensus amongst the board members, the best thing to do is to have those emails and not put the manager on until a decision has been made, so that it is not an official record. Understand too that if the association has a general email account where homeowners can send requests for service work, so xyzcommunity@gmail.com, right? That email is, pursuant to recent DBPR declaratory statements, considered official records of the association. So from one board member to another, not general email address, official record, put the manager on the email, correspondence, official record. So understand those distinguished things. Also understand that all of those are subject to subpoena if there's litigation. So don't think that you can hide. The only thing you can really will never see the light of day is when legal counsel is on them. All right. So what are not? This is really what you need to pay attention to. Communications with legal counsel, obviously protected by the attorney-client privilege. Doesn't mean every communication that's ever been sent to me is privileged, but most of the time I can argue that it has a legal aspect to it, and as a result is privileged and not subject to disclosure or inspection by members. Information secured for the approval of lease, sale, or other transfer. So this would be background checks. You run a background check as part of your approval process. That background check is not subject to inspection by members. Personal records of the association employees, disciplinary, payroll, and insurance records. I always get the question, does this include management contracts? No, management contracts are official records. What is not is the particular manager's FICA, right, withholdings on their paycheck, or are they enrolled or not enrolled in health benefits? Those types of items are not official records. Medical records of the parcel owners of the community. Typically, this is seen when there's a Fair Housing Act accommodation request, and there's a letter saying that this person can have a dog over a certain weight limit because they are handicapped. That doctor's letter itself is not subject to inspection for obvious reasons, medical privacy laws. and the other personal identifying information, social security numbers, driver's license, credit card numbers, email addresses, except unless they appear on that electronic consent notice. In that instance, they are subject to official records, but otherwise, if I'm just emailing the association, that would not be subject to disclosure. Telephone numbers, fax numbers, emergency contact information, the things you would usually go ahead and see. Now, you can consent to that being part of the official records, but I have no idea why you would want to do it, but you could certainly go ahead and do it. Any electronic security measures, so those would be the passwords. If you guys use QuickBooks, that kind of items are not part of the official records in any software associated with that. So we've talked about what are official records. Assume they're everything except the exceptions I've outlined. What happens if a member makes a request? Let me go through why this is so important. Because if you do not respond and produce the records for inspection, and we'll talk about the nuances in that, within the 10 business days, the homeowner can sue the association and get statutory penalties of $50 per day up to a maximum of $500, but they can also get their legal fees if they prevail. Meaning that we could go ahead and have a situation where it's a $500 penalty, not a big deal, right? But because they had to file a small claims complaint and you had to pay me to defend the case, and they ultimately prevailed because you didn't comply, and I'm a good attorney, but if you didn't comply, you didn't comply. There's not a whole lot I can do. You could end up owing the $500 plus $5,000 in legal fees. So it's very, very important as part of this process to, one, acknowledge when you receive an official records request, shoot them an email, shoot them a letter. We've gotten it, we've received it, and tell them when they're going to be produced, right? Put that in the record in writing. That almost nearly resolves every official records dispute, because I have now put in, if we get into litigation, acknowledgement that I received it and told them when it would be available, right? Now the burden's on them to say, well, I went to the meeting, but they said it was available, but it really wasn't. Very, very hard fact to prove. Most of the times the courts will find the association witnesses credible and find that you did at least attempt to produce it and be able to escape liability there. But those types of written correspondences, even emails to the owner, acknowledging receipt and telling them when they'll be made available, make sure it's within 10 business days, is of the utmost importance. The HOA has a copy machine on site. It can provide copies if the request is no more than 25 pages and charge a reasonable cost. If it's in excess of 25 pages, send it out to Kinko's or FedEx or something like that and have the owner pay the cost for the copying at that point in time. The association can charge a maximum of 25 cents per page. And in addition, the association can charge for personnel costs to fulfill the copying requests. Understand this is different from having to pull the official records, right? So owner says they want bank statements from 2 years ago on these particular months. It takes a half an hour for the manager to go pull those. That cost can't be passed on to the homeowner. What can be passed on is the homeowner shows up, I hand them a copy of it, and I say, you can look at it, you can take pictures with your phone, but if you want a copy of it, we're gonna give it to, Sally over here, and Sally's gonna go make copies. If it takes her more than a half an hour to make those copies, then you can pass on the cost of that. The association can make the option for them to go ahead and view them electronically. So a lot of times if I get a records request that's very particular, I want to see these cash flow statements or the audits for the past 3 years, in lieu of doing the whole rigmarole of you can come in and inspect and look at them, a lot of times if the client has electronically available, so you just email it to them. Save everyone some time, very particular request, not really an option when they say all financial records for the past 7 years. At that point in time, we have to have an in-person records inspection because that could constitute a multitude of documents. And as of July 1st, members can use their smartphone scanners, whatever it may be, to go ahead and take pictures. We cannot charge them for the cost of that. The association can adopt written rules and regulations regarding records inspections. So the strongest thing that I recommend is if you have someone that is abusing this, is to adopt rules at a duly noticed board meeting stating that any records request an owner can submit one per month, and they will have up to 8 hours at the records inspection to go and inspect it. The DBPR has signed off and said those are reasonable rules. What that does is it prevents the person, the keyboard warrior, from submitting 14 records requests and us chasing our tails, trying to produce everything and track everything down and coordinate inspections and so forth. If they submit 14, we'll take number one, we'll do it in September. We'll take number two, we'll do it in October. We'll take number three, we'll do it in November, and it just pushes them out. Eventually, the homeowner will get frustrated and see that that type of harassing or abuse of the official record statute is not going to be worthwhile for their time. In failure to provide access within the 10 business days of receipt of a certified mail return receipt requested creates a rebuttable presumption that the association willfully failed to comply with the statute. That being said, it does not have to be via certified mail. It just creates a presumption if we end up in court. An email records request is wholly sufficient. I've litigated those cases. And because an email tells you when you received it, it pretty much creates the same type of scenario where when we get into court, I can't really deny that I got it if it went to the association's email address. And the penalty, again, $50 per day, up to a maximum of $500, knowing that attorney fees are the real issue here. All right, last section, we'll do a statutory update, but I will go through this pretty quickly here. So HOA dispute resolution, right? Let's talk about violations. That is what I see most often. John, we have rules and regulations that require certain activity or prescribe certain activity. They're in violation. What do we do? The first step is you can call the attorney. We can talk about the overall strategy, but realistically, go to your manager, right? And discuss with them what are the steps. What we generally see is 1 or 2 warning letters, right? Simple letter, hey, Mr. So-and-so, welcome to the community. You may not have known, but we prohibit this type of activity. We require that your trash cans can't be left outside on the side of your house. You got to put them in your garage, right? We prohibit dogs of a certain size within our community. We don't permit you to leave your RV overnight in the community. Those types of things. Warning letter, most people, when they get that, will go on the community social media page and complain, but ultimately comply. So not a problem. Problem resolved. Never had to get to legal, minimal time on the management company's hand, and we have compliance. What happens if they don't comply to the warning letter? Well, check your governing documents and understand that there's a fine process under 72305, right? That provides that you can levy fines statutorily $100 per day up to a maximum of $1,000. Think of HOA fines as the speeding ticket of the HOA world. You can levy fines in excess of $1,000 if provided for in your governing documents. So that's why I say check your governing documents. But most clients, unless they've adopted an amendment recently, they're capped at the $1,000. So it's a 2-step process. If we do the warning letter, they don't comply, we need to garner compliance. Let's give them the speeding ticket, right? 1, the board of directors at a board meeting should levy the fine, right? It should be in the meeting minutes that they levied the fine. Once they've levied the fine, a letter is sent to the homeowners. Hey, Mr. So-and-so, the board at this board meeting went ahead and levied a fine of $100 per day up to a maximum of $1,000 for your violations of having a giant sculptural horse in front of your yard without approval from the art committee, right? I literally had that case the other day. Please go ahead and comply. And in addition, this letter will provide, if you'd like to appeal this decision of the board, you have the right to appear before a fine committee, an independent committee, and make your appeal. And that fine committee will decide, give the thumbs up or the thumbs down as to the board's decision to levy the fine. At the fine committee meeting, those members are made up of non-board members or non-family members of board members. They are truly supposed to be independent. They will review why the board took their action, what evidence there is to show that there was a violation. They'll hear the argument of the homeowner if they do appear, and they will decide to uphold the fine in its entirety or decline to enforce the fine. They cannot modify the fine. They cannot change the terms. They cannot give a grace period. All they can do is say yes or no. Once they've made their decision, they send notice to the homeowner of their decision. The fine's upheld, the fine goes on the ledger, and it's now a valid and enforceable fine. And if they decline to enforce it, then the matter is resolved. Most of the time between the warning and the fine and suspension, a vast majority of people will comply. If you get to that point where you've exercised all of those and they haven't complied, that's when you pick up the phone and contact legal counsel. And we can go through a process of statutory demand for pre-suit mediation and eventually a lawsuit for injunctive relief. The reason I recommend the warning letter and the fines is, unless we're doing it for the first time, and I'm walking you through the procedural process, you don't have to get legal involved. You don't have to incur legal fees. And so as a result, it doesn't really cost you anything other than time to go ahead and go through that process. And again, it gets most people to comply. I put down here self-help. So some associations, based on your governing documents, do have the ability to exercise self-help, meaning that they can go on the property and they can remedy a violation. The most of the time, what we see is somebody that's not taking care of their lawn, right? They're up north, their landscaper quit, or for whatever reason, the grass is 2 feet high. The association, upon proper notice, can exercise that right. And if your governing documents provide, can then charge that cost back to the homeowner and collect it as an assessment. That's going to be in your governing documents. Talk to legal counsel before you exercise that, right? Because even though your governing documents say you have the right to do that, there's a lot of nuances there, especially if the homeowner is an absentee and they're there. What happens if our contractor shows up and the guy comes out with a gun, right, and tells them to get off the property? What happens if the guy calls the sheriff's office and says they're trespassing on my property? So I like to always talk to clients before we exercise the self-help. They can then make a risk assessment of how they want to proceed. If it gets to me, right, this is hopefully the 10% who just refuse to comply. We really shouldn't be living in HOAs. They should live in some nice farm somewhere else. But when you live in an HOA, you agree to accede to the use restrictions. And but there are some people that just feel that they shouldn't have to. It comes to us for statutory demand for pre-suit mediation under 72311. It's a pre-suit requirement. It has to be done. And if that does not resolve the issue at a pre-suit mediation, then we can file a lawsuit for injunctive relief, essentially asking the court to compel the owner to comply. If they do not comply, they can be put in jail. So that is the end of everything. Is the person just won't comply. The court can find them in civil contempt after the injunction's entered and they still refuse to comply, and put them in jail. And typically, I've only had to do that twice in my 13-year career, but typically at that point in time when the sheriff shows up, we get compliance. So dispute resolution under 72311. Know that this applies to basically all covenant enforcement matters, any types of violations. It also applies to uses or changes to the parcel in the common areas and amendments. So that would be a situation where the homeowner is suing the association or wants to sue the association. They would be required to send a demand for pre-suit mediation. Meetings of the board, access to official records. Those are the types of things that are subject to pre-suit mediation. Importantly, collection of an assessment, a fine, or other financial obligation, not required to go to pre-suit mediation. The demand, there's a specific statutory demand. You should know about it. You can read it in 72311. Understand that if you go to pre-suit mediation, you got to be with legal counsel. No ifs, ands, or buts. The consequences, one way or the other, you need to be in the hands of a really good attorney. Failure to participate. So let's assume, because if we're going through a covenant enforcement and you're my client, we would always send a demand for pre-suit mediation, right? What I generally see is clients that don't have a management company, right, who receive this in the mail. They have no idea what a demand for pre-suit mediation is. They go, we don't want to waste the money, right? Well, what happens if my client fails to go ahead and participate? You cannot recover fees in a lawsuit, even if you win. So let's assume a homeowner sends a demand for pre-suit mediation to my clients because they failed to comply with an official records request. My client says, no, thanks. We don't want to participate. We don't want to incur the fees. The homeowner then sues the association in court and says, Judge, they failed to go ahead and participate, and they failed to produce the records. That homeowner ultimately loses. For some reason, your attorney can come in and prove that that homeowner missed some step in the records request process, Or maybe we did produce them and the homeowner's claim was full of baloney. And you've incurred $5,000 in legal fees to defend that action. If you did not participate in pre-suit mediation, you cannot get that $5,000 back as the prevailing party. Whereas if you have participated, you would be able to make a claim for prevailing party attorney's fees if you prevail. So if you receive a demand for pre-suit mediation, always go, call up your attorney, call up your insurance carrier, maybe there's insurance defense coverage, but always agree to participate. If we are pursuing a covenant violation, we will always have that discussion with the client. Yes, this is required prior to filing suit. And then HOA litigation, again, I talked about this. This is the action for injunctive relief, requesting the court force the owner to comply with the RV parking restriction, the oversized dog restriction, items like that. Importantly, let me jump back real quick. Importantly, attorney's fees, assuming you participated in pre-suit mediation, are recoverable. Two exceptions to that, not exceptions, two caveats. One is it's a reasonable amount of attorney's fees, right? So the court could say, yeah, you spent $10,000, but I believe, the judge, I believe $5,000 was the appropriate amount. So even if you prevail, the court can cut your fees. That's how we refer to it and say, we don't believe that was reasonable. So that's a risk. Number two is it's very possible, I've been involved in many lawsuits where the association wins on some parts, the homeowner wins on some other parts, right? And that means that the court could say there is no prevailing party. You know, nobody won clearly one side or the other. So I'm not going to award attorney's fees. So when we go into HOA litigation, discussion I always have with the clients is, what's the goal, right? The goal is to achieve compliance with your use restrictions, your rules, and so forth. My goal as your attorney is to get you to that end result as cost efficiently as possible and quickly as possible. If we can recoup attorney's fees, icing on the cake, but never presume that we're going to be able to recoup them, right? Or at least take that into your risk assessment when I'm telling you, hey, the guy's agreed to comply, but he wants you to waive half your attorney's fees. Probably a good deal to take in those scenarios. So it's never a guarantee. You have the right to do it, but there are some hurdles that a court could go ahead and put up to preclude that. So again, don't lose sight of what the goal is. The goal is to achieve compliance. That is the win. Few extra slides here. MARTA preservation. Just know that there is a statute out here under Chapter 712 that if your original governing documents are coming up on the 30-year mark since they've been recorded, you need to be in touch with legal counsel. We keep track of this for our clients. When we take on new clients, we say, when were their governing documents recorded? And we talk about this MARTA preservation process. But just understand this is a statute in place that can eliminate the enforceability of your covenants if you don't preserve them or renew them. And there's a methodology to go ahead and do that. Or if they have expired, you're past the 30-year mark, there's a revitalization process. Very, very nuanced, beyond the scope of this board certification course. But take a look at your governing documents. Were they recorded? Are we coming up on 30 years? If so, we need to talk to counsel about how we go ahead and do that. If we're past the 30-year mark and they were not preserved, we need to talk to legal counsel to address that. Statutory updates. These are things that recently came into effect in the 2021 session and 2022 session. For new board members, I'm sure the management companies all know this. Prior to delinquencies being sent to the attorney for collections, right, which is where we put the lien on the property and we can eventually foreclose, this has to be sent to the homeowners. It's called a notice of late assessments. It's a final warning letter that's sent to homeowners prior to going to legal counsel and incurring fees that says, hey, if you don't pay this, we're going to send it to the attorney and you're going to have to pay them too. So just know that that is a requirement. When a new collection matter comes to our office, we go ahead and request a copy of this so we can verify it's been done prior to starting work on our end. Rules and regulations. So we talked about declaration of covenants, bylaws, articles, ARC restrictions, rules and regulations are about the same level. They used to have to be recorded to be enforceable because they were defined as a governing document under the statute. They are no longer defined as a governing document. I still recommend that you record them. The cost is pretty minimal. And it ensures that anybody that buys in your community, when the title company writes title insurance and they run a title report, the latest version of the rules and regulations will show up in addition to your declaration, your bylaws, and so forth. I don't think that hurts, because when I get into covenant enforcement, many people say, well, I never knew about the rule. Well, do you have a copy of your title policy? Oh, yeah, I do. Okay. Can you go to this provision right here, which disclosed the existence of these rules? Oh, right. So it just makes my life a little bit easier. So I recommend it be recorded, but not required anymore. Understand that on rental restrictions, if you want to go ahead and implement rental restrictions, requiring a minimum lease term, number of tenants you can have, tenant approval requirements, those only apply prospectively to people who opted in to approve the amendment, or those people acquiring title after the date that the amendment is recorded. It used to be that it applied to everyone in your community of the past. Now it's only people who voted in favor or in the alternative that purchased after the recordation. There is an exception that you can put in a minimum lease term, and you can limit the number of rentals to no more than 3 per calendar year. If you implement solely those amendments as rental restrictions, they apply to everyone, not just those who voted in favor and those that acquired title after. But other than that, if you want to do background checks, if you want to have the ability to approve or deny, those are the types of things that apply prospectively. And then 72316, in the wake of COVID, emergency powers have been better defined to state that hopefully we never have another pandemic, but if we do, we can rely on the advice of emergency management professionals and health professionals in determining whether to open or close elements of the community. So in conclusion, you can go ahead and read this, but understand that the HOA statute started in 617. It then got its own statute. More and more, the legislature is recognizing that HOAs have similarities to condos as far as community association laws. And so we are seeing more and more oversight by the legislature as it pertains to homeowners associations, where the DBPR's jurisdiction, what is going to be required, and so forth. So very important. We leave this as our final slide only because understand that coming back next year, right, we're going to give a legislative update. And throughout the year, we give legislative updates to clients and presentations. You got to be aware of what the current law is. Even if you don't have to understand it. You just have to remember, hey, I went to this presentation and the attorney mentioned something about this, right? It's that flag that sticks up the back of your head. Then, call the manager or call legal counsel and say, hey, we had this situation. I thought you said there was a change in the law on this. That's the goal of these presentations, is to make you educated, understand what goes to the manager, what goes to the attorney, and allow you to be best suited to exercise that fiduciary responsibility. So with that being said, that was slide 57. So we've done it. I am going to stick around and answer the Q&A session. So feel free to stick around. It's free legal advice. So how often does that happen? Almost never. But that being said, you have completed your duties. Brenda, I don't know if my office is going to be doing it or your office will be doing it, but we have certification forms that we will be sending to every one of the 102 participants online here through your email address when you registered for Zoom. If you don't get it by October 15th, please reach out to Brenda or my office, and we will make sure that we get that to you. When you do receive the certification, put it in the official records of the association. That way, if anybody ever complains that you don't know what you're doing, you can say, wait, I went to a board certification course, and feel better about yourself. So with that being said, I do want to thank Vesta one more time. It's very generous for you all to allow me to participate in your events, Brenda and Kevin especially. And with that being said, thank you all for your time. Stay safe out there. I'm hoping by the end of this presentation, the hurricane will have moved northward and out of our area.
Brenda, you're muted, but I will say, John, we have a bunch of questions. Do you want to start? And I can read them off to you if you'd like.
Sure. Is it in the Q&A?
It is.
All right.
So
go ahead.
Yeah, the first question we have was from around 10 o'clock. It says, are directors the same as presidents, vice presidents of the HOA community?
Yeah, so excellent question. I get that a lot. So they are the same persons, but they serve in different capacities. So when we have an election of directors, that is who is on the board of directors for the association. In almost every HOA that I represent, once that board is seated, they will then have an organizational meeting and elect the officers of the corporation. So that would be the president, the vice president, the secretary, and the treasurer. I only have one client who's a cooperative where the members actually elect the officers of the corporation. One other nuance, check your bylaws. It's rare, but it is a possibility that you can have an officer of the corporation who is not also a director. And there are scenarios where that comes up, where they say, we want this former person who's no longer on the board to continue to be secretary. If it's permissible pursuant to your bylaws, you can certainly do so, but that is the rarity. Most of the time, the president, the vice president, the secretary, and the treasurer are made up of directors and are selected at the organizational meeting of the board of directors. Good question.
The next question, on notice of meetings, instead of mailing out notices, can you just post meeting on a bulletin board at the front gate?
Yes. So the standard for board meetings is a conspicuous posting on site at the association 48 hours in advance of the board meeting. The only exception to that is membership meetings, which require affirmative mailings or electronic notices to members, and board meetings where a special assessment will be considered, or board meetings where there is a change to parcel use, right? So if the board's going to adopt rules that affect a parcel, what you can or can't do on your parcel, 14 days written notice. If the board is going to adopt a special assessment, 14 days written notice. If the board is going to have a membership meeting, notice in accordance with your bylaws. Other than that, posting is fine, 48 hours in advance.
All right. How do members of the HOA, not board members, obtain copies of the governing documents? Can they be refused?
One, when you close in your home, you should get a copy. And if not, you should go to the management company or the association and request a copy. You might have to pay a fee, right, to go ahead and do it. Or in the alternative, you can make a records request.
Okay. You state in mandatory reserve system, the board must propose a budget that fully funds reserves. Define fully funded, please. We have a reserve study that established reserves. Is this study amount what determines fully funded?
So that's a really nuanced question. So my opinion, and you may hear differ amongst attorneys, is a reserve study is but for one professional opinion as to what the reserve should be. I don't think that if I go out or I have a client that goes out and gets a reserve study, that my reserve schedule at the next budget meeting has to parallel that reserve study line by line. I think that the board can seek the opinions of contractors or other professionals if they have questions about particular portions of the reserve study and whether they believe that's accurate or not. So let me walk you through a hypothetical. We go get a reserve study. It talks about how the roadways will cost $200,000 to go ahead and repave. And we believe that there's a 5-year remaining useful life on those roadways, right? Client disagrees. Client says, wow, we really don't want to do that. We go out and hire an asphalt company, come out and give us a bid. They say, yeah, it's $200,000, but we think you got 10 years. Now I have substantive information to rely upon to differentiate my reserve schedule versus the reserve study. Do I think the board can just make up numbers? Absolutely not. I think that if you get a reserve study, you got to go ahead and find a justification from varying from that. But I don't want you to think that that thing is set in stone. You can't seek alternative information in preparing what your reserves should be.
Okay, fantastic. We have 24 questions left in 16 minutes. So maybe we can get through this. What would be the professional recommendation for establishment of regular funding of or maintenance of drainage ponds within this person's community so that the ponds will be mowed in reasonable frequencies, which meets the burden of city ordinances? Would this fall under Robert's rule under a quorum?
So maintenance of the common areas is at the board's direction. The board should be consulting with their landscape company to determine how often that should be done. And at the end of the day, it will be left up to the board's business judgment rule. Unless the members went ahead and had a special membership meeting and implemented something mandating it be cut more often, it's going to be in the board's hands.
How do you address handling an HOA board that's not meeting any obligations of the seat held? For example, not attending meetings, not voted on associations matters in over a year, and the member still has another year before their term expires.
As to a particular board member, unless your bylaws provide for the removal of a director for failing to attend a certain number of board meetings per year, you're stuck with them. And so if it is an individual board member, then you can talk to them about resigning their post. And if they don't want to resign, then you can certainly go through a recall process. That's a provision under 720, I think 303, to recall that board member if you think that they're not properly exercising their duties. You could also hire private legal counsel to go look in and provide you some guidance there.
Do foreign nationals who sit on a board enjoy fewer protections under law when there is a dispute with overall board performance by the owner group?
No, not necessarily. So all board members on HOAs are required to be indemnified under Chapter 617 and the Articles of Incorporation, meaning that so long as they don't engage in gross negligence or willful misconduct, if somebody sues the association is going to have to defend them and pay for their legal expenses. And that's why most associations carry a director's and officer liability policy to hedge against that indemnification requirement. Nothing under 617 and no articles of incorporation that I've ever looked at distinguish between foreign nationals and U.S. citizens.
If a quorum is required, for example, a budget meeting, and there is no quorum, how does the board proceed?
So the board has to go ahead and adjourn the board meeting and reschedule the budget meeting. And if they cannot get the board together prior to the next fiscal year coming about, the current budget will remain in place until they can have that budget meeting.
Okay. For member elections, what about homes owned by trusts?
So check your governing documents. Most bylaws provide for a voting certificate or designation of the voting member. And that's something that's filed with the association that says that this particular trustee or this beneficiary of the trust is authorized to cast the vote. And until that is changed, that is the individual that the board will accept a vote from.
Okay. This has nothing to do with you, but how do we as board members terminate an unqualified counsel that was chosen by the board?
As members, I don't think you have the ability to. The selection of property management companies, landscape companies, attorneys is at the board's discretion. So the only way that you can really go about that is to express your displeasure at a board meeting and try to convince the board that they should be swayed by your argument, or in the alternative, to recall the board and have the replacement board put in place, and then have that new board decide what to do with legal counsel.
Excellent. Concerning elections, if an individual is running for re-election to the board and that person owes money to the community, but they are in litigation about that amount, does that make them ineligible to be a board member?
That's a really nuanced question. I would take the opinion, given those facts on its face, that money is due until a court determines otherwise. And so I would likely go ahead and opine to a client that you should deem them ineligible.
Okay. Can an at-large or honorary board member be elected each year as a non-binding person on the board, essentially in waiting for any potential vacancies which might occur during the non-election periods?
Legally, no. You have to go ahead and elect the number of directors that are up for the election by the vacancies that are left. Could you have someone waiting in the wings and deem them an advisor to the board or a consultant to the board, or create a committee in which that individual would operate? Certainly there are ways to achieve practically what I think they're trying to get to, but they would not be in the position of be deemed a director of the association.
If you scan documents, must the hard copy be retained?
No. So if you scan documents, so for example, we get the annual audit, right? And the annual audit comes in a cover letter and it gets scanned. As long as I have a copy and can produce that copy that satisfies the official records requirement, there is nothing in the statute that mandates that you have the file cabinet.
Okay. What if a resident is out of town for a period and receives a warning letter? Will they be given that benefit of doubt if a fine was levied?
No, not necessarily. So a warning letter gives a compliance deadline, and that compliance deadline has to go and be met. A fine will be provided and should be sent to not only the owner's partial address, but the mailing address of the individual. And if we have an email address, we should email it to them. Every association should strive that any way that I can get this information in the owner's hands, we should do it. Because the hardest thing from my perspective as an attorney when I go to enforce is somebody saying, well, I never got it, right? And if I can show the court that I went over and above what was required by statute, I think it just makes the enforcement process so much easier.
Excellent. Does Florida Statute 720.306 apply to Airbnb rentals as well as payments of the county bed tax?
Say that again.
Does Florida Statute 720.306 apply to Airbnb rentals as well as payment of the county's bed tax?
So I'm assuming that pertains to the eligibility to run for the board of directors in a delinquency, which would be under 720.306. So non-payment of any monetary obligation owed to the association is the standard. County bed tax or anything to do with Airbnb would not. And importantly, violations of the covenants, so long as there's no monetary obligation alone, does not exclude someone from being eligible to run for the board. So if you're in violation for an ARC improvement that was not approved or the board doesn't think you complied with the plans you submitted, the association hasn't levied fines and you're just in violation, you're still eligible to run for the board.
Speaking of which, thoughts on realtors serving on a board? Is there a conflict of interest?
I've had that question come up before. Not so the standard for conflict of interest is whether a decision of a director will result in a financial benefit to them. That's the standard we look at. And absent that, no, it would not. Now, have I had a situation where a realtor got on the board, had access to everyone's email address, and all of a sudden everyone started getting emails from that particular realty company? Yep. And have I sent a cease and desist letter and pushed back on that? Yep, I have. But it is not necessarily a conflict of interest unless there's some sort of self-servance by virtue of your position as a board member, case-by-case basis.
Okay. Regarding ARC regulations, must substantial uniformity be objectively defined? Once a list is established, may the board add additional restrictions if governing docs say they may adopt reasonable rules?
So I'm assuming that these would be ARC guidelines for a particular community. So take a look at your governing documents. There's two ways ARC guidelines can be amended. One is if the governing documents provide, the board defines what the ARC guidelines are. The other one is, again, governing documents, is sometimes the ARC committee itself can define what its guidelines are. So it is governing document driven. But in either case, absent a requirement the membership have input, it would be the board or the committee that would define additional restrictions. But again, check your governing documents, because sometimes I've had communities, and I think of a few in Indian River County, where it was required that the board can adopt ARC guidelines, but the membership had to ratify that decision within 45 days or something like that. So it's really governing document driven. Good question.
All right, you're very popular. We have a few more here. Do the Florida statutes make any mention of the rights of owners vis-a-vis board meetings who don't live on the community of which they are members?
So every member under a 720-303, I think it's 2C, it talks about the board of directors meetings. And it requires that anytime a quorum of the board gets together, members have the right to attend and members have the right to speak on every agenda item. Members also have the right to record such board meetings. So if you're a member within a community, you have every right to appear and exercise those rights. I think the question was leading, well, I'm a director on this association. Can I go to another association board meeting? If you're a member of that association, yes. If you're not, then no.
Okay. If a person has filed violations, can they sell their home and walk away without resolution?
Good question. I love this one. So in the process of selling your home, there is an estoppel that is provided by the association, which tells the buyer and their lender, if they have a lender, as to any unpaid assessments. But there's also this little provision under the statutory form that says, are there any outstanding violations or fines? I cannot tell you how many times our client has strategically made the decision not to pursue a violation or a fine because the legal fees would have been too much, and they just sit and wait, right? And then a year later, the person puts their home up for sale, and we're going to get a check for all our fines, right? And we're going to get compliance because the new owner is not going to want to buy a home and immediately be in non-compliance with the association. So the estoppel form is the essential form there, and it opens a dialogue. And sometimes we have that the seller, the violator, will fix it prior to closing. Sometimes we give the buyer the ability to go ahead and cure it within 30 days, and then they negotiate with the seller some discount on the purchase price. But it is the point of most leverage for an association is during that process.
Okay. How can we change? Let me try to reword this here. How can we change? This is okay. How can we change that post meetings won't just be on a bulletin board?
So the requirement is conspicuous posting on the association property 48 hours in advance. That being said, we talk about what is the bare minimum and what is the best practice. Electronic communication is so easy these days that I have many clients that will, if there's an email list, email out notice of the board meeting with a copy of the agenda. The management companies can very easily do that. I have other clients that if there is a neighborhood social media page, they'll post notice of the meeting. They're not going to respond on social media. I don't tell clients to use social media to communicate with their members, but they'll post notice of it, right? And so I think it's convincing your board that putting members on notice of board meetings and having the opportunity to attend is going to go a very long way in showing the members that you are being transparent about how you operate, one, and number two, that you care about membership input. Doesn't mean they'll always agree with you, but you want to give members the opportunity to attend, express their input, express their concerns, and then make an informed business decision.
Okay, our governing documents were written in 1986. Are they not enforceable because they are over 30 years old? How do we bring them into compliance?
So 1996, 2006, 2016. So the first thing I would do, assuming you were a new client, is we would go in the public records and see if the governing documents were preserved. It may be something that you don't know about, right, but was done by legal counsel at the time or the board at the time. That's a recorded document that will show up in the title report, very easily determined. Let's assume that preservation exists, right? You're good for another 30 years, problem solved. I look great as your attorney. Let's say the preservation wasn't done, right? Or we can find a preservation, but it was done improperly, right? And there's some procedural defect. We now switch from preservation to what's called a revitalization. There's a provision under MARTA that says, look, in an HOA, if it's been beyond 30 years of the root of title, right? And that's a defined term. The association can revitalize the governing documents. There's a vote of the membership that's required. You have to get 50% plus one for people to say, yeah, we want to continue with the covenants. And then you have to send it to the Department of Economic Opportunity up in Tallahassee, and they have to sign off on the revitalization. Their standards aren't that high, but it's a process you have to go through. Once they give you the thumbs up, then you have to record a document that revitalizes your documents. The good news here is if you're beyond the 30 years and people opt out of your community, say, hey, beyond the 30 years, see you later, no longer part of the HOA, the revitalization process can allow you to recapture them. If 50% plus one of your membership says, yeah, we want to continue. So there's no real escape from the HOA so long as we can get the membership vote to revitalize. But good question, probably get with legal counsel as soon as possible so you can get those issues figured out. A lot of consequences of expiring. One of them being is that you have the authority to levy assessments, but they're voluntary. And if people don't pay them, you really don't have rights. So get with legal counsel.
Perfect. If an HOA has a sue-happy homeowner, can the HOA countersue for the homeowner's frivolous lawsuits that caused the directors and officers' policy to be canceled?
You can't, I mean, there's a cause of action called malicious prosecution, which theoretically could be used. I never use it. What I generally do is there's a provision, it's 57105 Florida statutes, which allows me in a lawsuit, if it's frivolous, right? Pretty high bar, but let's assume that it is frivolous, right? That I can send a notice to opposing counsel and the individual that brought the lawsuit that says that if you don't drop the lawsuit within 20 days because there's no legal merit to it, and I win, I'm going to get all my legal fees against not only the homeowner, but their attorney too. And so that is a very strong mechanism to really have opposing counsel look and say, is this worth it? Because that's money out of my law firm's bank account if I lose here. And so that's one methodology. A lot of times I have clients that do live in sue-happy communities. They just have really high deductibles on their D&O policy. I mean, like $25,000, $50,000. And, sometimes you just got to deal with those types of situations.
All right, 5 left. Fully funded question clarification. Reserve study says you must put $500,000 annually into reserves. Board of directors say we only do $300,000 in an effort to balance budget.
Mm-hmm. So the question becomes, what was the justification for the $200,000 discrepancy? If the board can justify that, then they have the business judgment rule to protect them and say, yes, you properly exercise your duties. The question becomes, what's the justification? The board making it up without relying on other bids or other additional information from professionals would put me in the ground where I feel like I am on very thin ice. So I understand wanting to balance budget. I understand not wanting to raise assessments so much. I get that as a motivation. But at the end of the day, you're required to exercise your fiduciary obligation, and you have to be able to have some reasonableness or soundness to your decisions. Slashing $200,000 off the reserve budget components without justification puts you on the grounds of, is that a breach of fiduciary duty or not? And so just thin ice, talk to the board. Maybe there is a legitimate reason, right? Maybe the lifespan's longer than what the reserve study opined. We don't know. But those are the types of things that I would look into and then go over risk analysis with the client.
This one's easy, and I know the answer to this. Do I make requests for official documents, budgets, et cetera, to my HOA manager?
Yes. You can also send it to the HOA general email address. I always recommend that if I represent a homeowner, which I rarely do, but if I do, send it certified mail and email. Just send the email, print it out, put it in certified mail, send it to. Make sure they got it so we don't run into any issues of when they fail to respond that we didn't do it the right way.
If a director on the board has specific financial interest for benefit, would that then be considered a derivative?
So if the director has specific financial benefit in a particular decision of the board of directors, there's a procedure under the conflict of interest statute in 617 that requires that director to disclose the financial interests, to abstain from participating in that vote of the board of directors, and then the board can then go ahead and vote. So it does not mean that the association can't do business with a director who owns a landscape company, but there is a very strict statutory process that has to be followed. And if it's not followed, it is a conflict of interest, and it could raise grounds for a derivative shareholder action under 617, something we don't want to get into.
How long can newer I don't know if this is BOA or HOA developments, but how long can newer developments within a master HOA, okay, it is HOA. How long can newer HOA developments within a master HOA not contribute to funding, and would developer need to fund?
So in a pre-turnover community, meaning it's run by the developer under the latest version of the statutes in the recent amendment does not have to establish nor contribute toward reserves and only has to deficit fund. There is no limitation on how long that process can take for the development of the community, except two things. One is look at 720.307, which sets forth when the developer has to transition control to the membership. And then take a look at the declaration and bylaws of the community. Those may require the developer to turn over within a certain time period. For example, I have a client down in Stewart that they weren't at the 90% build out requirement yet. We're not required to turn over, at least that's what they thought. But the governing document said that you have to turn over within 15 years of breaking ground on the first time. And so we went to the developer, and the developer said, I still don't agree, but I'll agree to turn over. So governing documents, 720.307. Good question.
Last question. Can a management company refuse to accept assessments without alerting the member why, and then send you to collections?
I'm sure there's some nuances to this, but there was a case law that came out in 2011 that says that associations have to go ahead and accept payments and partial payments. And a management company as an agent should be accepting any payments that an owner makes. The one exception I can think of is if I owe $5,000 and I walk to the manager's office and I write payment in full and I write a check for $2,500, the manager is allowed to say, I'm not going to accept that because it's not payment in full. And we don't want to get up and in a court satisfaction situation. So, but if you're making partial payments, there's no restrictive endorsements on the check. The check should be deposited and an updated account statement provided.
All right. So I'm gonna turn it over to Brenda for final thoughts, and just remind everyone that we will send a copy of the PowerPoint as well as a link to the recording of today's session to everyone that attended. And you can always get this information from this webinar and previous webinars, as well as upcoming webinars at vestapropertyservices.com/webinar. So thank you.
Thanks, Kevin. And thank you, John. As a CAM, I'm still, a licensed manager. I always learn something from your webinars, and I appreciate it so much. I appreciate the attendees today. And we did drop in the chat our information. So if you are in the need of a management firm or a good attorney, you know how to reach us. Or if you have questions about management of your association, please feel free to reach out and contact me anytime. I'd be glad to assist you. Everyone stay safe during the storm. Again, thank you so much for attending, and have a great rest of your day.